Hi, it's Jen Rubin, editor-in-chief at the Contrarian. Delighted to welcome back Mary McCord from her Georgetown office, it looks like. She is a constitutional expert on many things. And in fact, we had intended to talk about one constitutional crisis, and in the meantime, others have come along. So she is nimble, if not anything else, and she's many other things. So let's talk about that. Los Angeles. I got the chance to interview Mayor Bass, and although, as she points out, there was never justification for deploying the National Guard and the Marines because we're talking about a few blocks within a city of somehow 500 square miles or so. As of today, there is really nothing going on. The only violent activity is ICE people continuing to drag people out of Home Depots. There is no rioting, there are no demonstrations. At what point does the government lose any plausible argument to continue to deploy the Marines and keep the National Guard under federal control?
Well, we don't have a judicial answer to that, right, from the courts. The statute, though, it's interesting because the statute does definitely commit to the president the ability to determine sort of how many troops are necessary and for how long. That's one of the things that's more clear about the statute, frankly, more clear than some of the other determinations, such as whether there's a rebellion, whether there's an invasion, or whether with regular forces the president is unable to execute the laws. The part of sort of once you've met those predicates, then in terms of the necessary number and duration is a little bit more committed to the president's discretion. But this is where I do think that the Ninth Circuit's ruling, even though it was a stay, it's just a preliminary decision to freeze things. Well, not freeze things, actually let things continue, freeze the lower court's ruling pending more fulsome briefing. There is some helpful language in there on this very point about what is left to the president's discretion. And even though the Ninth Circuit very capaciously defines the discretion to be given to the president in manners of national security and foreign policy and things like that. And I would say that this is not about foreign policy, but they trace back the history of Insurrection Act. I think they inappropriately say that Section 406 was actually has its lineage in the Insurrection Act because it's actually different. And they say it's very capacious and it's very broad, but they say it is subject to review based on whether the president's actions are done in good faith within sort of the scope of honest judgment. The Ninth Circuit, for example, read from not from the statute, but read from a case that was decided under sort of what is the authority of the executive when it comes to making these types of determinations, which says that it has to be done in good faith. And what the Ninth Circuit said is old case law does not compel us to accept the federal government's position that the president could federalize the National Guard based on no evidence whatsoever, and that courts would be unable to review a decision that was obviously absurd or made in bad faith. And it goes on to say that, look, when the president exercises an authority like this, confided to him by law, the presumption is that it's exercised in the pursuance of law, and that it is within a permitted range of honest judgment as to the measures to be taken in meeting force with force, in suppressing violence and restoring order. So that would suggest, to your point about the mayor saying there's just no activity going on here that is destructive or riotous or anything like that, there could at least be an argument made that even under the Ninth Circuit's stay ruling, that there is no evidence, right, of a need right now for the federalized National Guard to be there, and that it is not in good faith, it is not a reasonable exercise of honest judgment to have the federalized National Guard there still when the conditions have changed. I can make the arguments on the other side of that, but I'm just saying there is a basis there.
Yes.
At least argue at this point, continuing. I mean, I could see continuing for a little while to make sure it doesn't all just blow back up. But at this point, I think an argument could be made that if you continue it long enough when there's nothing going on, then that's no longer within the permitted range of honest judgment.
Now, one of the other issues that the Ninth Circuit left open was the degree to which Posse Comitatus was violated. And that's really the prohibition, with some exceptions, for law enforcement type activities. Based upon what you know, have they stayed on the right side of that divide? There was one report that they were detaining someone that turned out to be not the case. What's your best information about what they've actually done and are doing right now?
So, in the last few days, I just think we've heard sort of very little about this. I mean, the news has been overtaken by other events, the strike in Iran and other things like that. But what the government has, what the California government and the governor of California have said in their briefing to Judge Breyer, and I should rewind just a little bit. Ninth Circuit, we've been discussing, issues its stay ruling. Like you said, it very explicitly says we are not ruling on whether the federalized National Guard troops are engaging in domestic law enforcement activity in violation of the Posse Comitatus Act, or even whether the statute the president relied on, 12406, is an exception to the Posse Comitatus Act. We're not ruling on that. That's not before us. So Judge Breyer, who was supposed to have a preliminary injunction hearing on Friday, had a very brief hearing and said to the parties, the state of California and the United States, can I still rule on something? Or has the Ninth Circuit taken everything away? I want briefs on that by Monday, which was yesterday. So California and the United States filed briefs yesterday. California says, to your point, we want some discovery about the extent of law enforcement activity that the National Guard is undertaking. We want to be able to propound written questions called interrogatories, request documents, and maybe do some depositions of the people that have been sort of involved in what the National Guard is being asked to do, because it had already argued in between the temporary restraining order and the preliminary injunction hearing that had been scheduled. It had already argued, to your point, that they're doing more and more, that they're going out with the immigration agents on raids with them. They're not just guarding federal property or protecting federal property. They're going off federal property out into the community. There's been a report of one arrest, as you said, actually by the Marines, not the Federalized National Guard, raises also the Posse Comitatus issues. If the Marines are engaging in domestic law enforcement without an exception, and 12406 doesn't even apply to U.S. Armed Forces, only to National Guard. So they want discovery so that they can say definitively, yes, these guys are doing things they shouldn't be doing, and then potentially seek a preliminary injunction on that. The government yesterday filed its brief saying, and then responded to California saying, they can't ask for discovery. They shouldn't get any discovery. And necessarily the Ninth Circuit's ruling is assuming that the National Guard could engage in the execution of law, because the Ninth Circuit issued the stay on a finding of likelihood of success. The U.S. government was likely to succeed on its argument that they were rightfully federalized in order to execute the law, because the president couldn't with regular forces execute the law. So that must mean it's an exception. And then they say, at any rate, they're not actually engaged in any domestic law enforcement. They're just doing these protective functions. So that's where things stand right now. And it's now ball in Judge Breyer's court to say either, yes, I'll give you some discovery, what they want to do. Plaintiffs, California wants to have some discovery, and then file a new preliminary injunction motion on July 15th. We'll see.
It seems a very specious argument, since the Ninth Circuit specifically exempted Posse Comitatus, to argue that the Ninth Circuit really doesn't let you decide that, Judge. So that's one issue. It does seem that this would actually be extremely helpful, because we don't know what the line is, quite frankly. And if President Trump intends to do this over and over again, it would help to have, in fact, it would be necessary to have a very tight rule saying exactly what these people can do and not do. So it seems like that would be a helpful thing for them to do.
I agree, because I think, as you and I have discussed before, the Department of Justice has long taken the position that performing these protection of federal property, federal officials, federal functions is not domestic law enforcement, but that's actually just a Department of Justice opinion. So, even that alone, assuming they're really just standing and protecting federal property, that actually hasn't been decided by a court. But then the question is, well, what is the extent, even if you assume that there's some amount of federal protection of federal property that they could engage in without that being called domestic law enforcement, what does that entail? Suppose somebody is trying to assault a federal officer. Can the National Guard make that a temporary detention of that person in order to turn them over to law enforcement? Or is that an arrest that is domestic law enforcement that they can't do? I mean, that's an open question. And so I think it would, particularly in these types of circumstances, if this is going to be something regular, which it would seem that it is, because people will recall the president's executive order was not specific as to LA. It said that, in the face of, there being protests and that type of activity, that he was authorizing the federalization of National Guard anywhere, in the country where these kind of protests, which have in some cases involved some acts of violence, that's a situation where the National Guard could be federalized and the U.S. Armed Forces could also be called out. So this certainly could repeat, and it's something that we need a judicial answer to. And probably that judicial answer, as with so many things, is going to need ultimately to come from the Supreme Court.
It is an uncomfortable state of affairs that, in some sense, Trump has done what he intended to do. There is this executive order there. No one has declared any part of it at this point unconstitutional. No one has kind of given any guidelines. So as of this moment, we might have it tested over and over again and repeated. And in some respects, that kind of reminds me of the other argument we were going to have, which was on the War Powers Act, which is he did it. And this is kind of this underlying sense, if you can talk to the broader issue, that he's getting away with it simply by doing it and racing so fast that the consequences and the courts can't keep up with them. Is that a realistic concern that you have?
It is, and it's interesting because that's something that I think some of us have been talking about who follow, constitutional law and particularly rule of law as it relates to federal government actions. That, in other administrations, and I'm not saying every administration has always abided by the law in every respect, that's certainly not the case, but, coming from the Department of Justice, there would be robust discussion and debate about the legality of certain executive actions before those executive actions take place. And because we have seen so many things that courts have thwarted, at least up until we get to the Supreme Court, and even the Supreme Court, in fairness, has thwarted a number of things that this executive has tried to do. It seems like now the burden has completely flipped. It's like the government just does the thing, puts the burden on the people impacted by this executive action to bring a lawsuit. And by then there's already been damage done, right? Like
Exactly.
you attempt to end all the foreign aid, right? And shut down USAID, and a whole bunch of stuff that's very, very harmful happens before people are able to get into court and get a court ruling. You put people on a plane and ship them off to a terrorist detention center in El Salvador, requiring people to then sue, and already a bunch of damage has been done. And sometimes you can rewind things and put that milk back in the bottle, but sometimes you kind of can't. And here we are already now, what are we, 2 weeks or 1 week? I don't know. I don't know time anymore, of having federalized National Guard and Marines in LA, and we can litigate it, but they're there right now. And so,
Exactly.
And the other thing is, suppose you were to say, okay, things are calm in LA, mission accomplished, go ahead and we can withdraw. And then, the government might say, well, yes, but the case is not moot. We still need answers to the questions. Government, meaning California, might say, we still need answers to these questions because you could do this again in California, or you could do it again in some other state. And I could see the government, potentially the US government, saying, oh, this is moot because the troops are no longer in LA, right? And there's no reasonable right now threat of this happening again. So there'll be this dance, I think, here. And the point is, we need some of these things to get resolved by the courts in ways that the executive is going to abide by those rulings, and that takes time when they're litigating. And this burden shifting, I can't tell you how important that is to me, because that is flipping. The onus should be on the government to try to do its best to do things lawfully, and not on the people to challenge when the government just does it and says, well, we'll do it and see if we can get away with it. Flood the zone. Everyone can't litigate everything, and some things we will get away with, and other things, we'll defend in court. And that seems to be where we're at.
Exactly. And I'll leave for another day whether we need to go back and revisit, beef up what used to be called Bivens suits, where you could actually hold people financially accountable for doing these terrible things. And that has been eviscerated by the courts. In my ideal list of democratic reforms, that may be Greek to many people, but it's high on the list because there's no disincentive for them to do these things. Let me switch gears entirely and talk about Emil Bove. He was a controversial nominee when he was put up for the Justice Department. He played a major role in the so-called corrupt bargain in the dismissal of charges against Mayor Eric Adams. And he has now been nominated, of course, for a circuit court position. And the suspicion of many people is this is his waiting room should a vacancy on the Supreme Court open up. There, as many of you know, was a truly eye-popping piece in the New York Times today from a whistleblower explaining that he has used some really absurd language, directing people in Justice Department to F the courts, to disregard court orders. Even before this happened, Mary, he seemed to be exactly the sort of person you don't want on a federal court. Give me a little sense of how bad a nominee this is and the danger of putting someone like that in a very important role at circuit court.
Yeah. Well, I mean, this goes back to people, your viewers will recognize that Emil Bove was, of course, Donald Trump's personal defense attorney in the criminal cases, some of the criminal cases brought against him, including the Manhattan case that went through trial. And so was Todd Blanche, who's now the Deputy Attorney General, and so was John Sauer, who's now the Solicitor General. He actually argued the immunity case. So what the president did is he kind of brought his defense team right into the Department of Justice. And I'll say that some of us did think, though, that because Emil Bove and Todd Blanche had in fact been federal prosecutors in their past lives working for the Department of Justice, that they would put that hat on when they got to the Department of Justice. But they kind of kept on the president's defense personal attorney hat, it seems like.
Absolutely.
And seem to, through their actions, and Bove was the first there because the position he holds as the principal deputy attorney general does not require Senate confirmation. So he was kind of their day one running the department until Pam Bundy got confirmed and Todd Blanche got confirmed. And so a lot of the early guidance and directions that were coming out of the Department of Justice that sounded very much like it is our job to use our tools, our Department of Justice tools, to do whatever the president wants, sort of legal or not legal. It's one thing to change policies. Every single administration changes their priorities and policies, but some of the things like what you mentioned, making this deal, really trying to, hang a sword of Damocles over Eric Adams' head to say, we will dismiss charges against you without prejudice. So as long as you help the president with his immigration plans, his mass deportation plans, then we'll dismiss the charges against you. Of course, that failed ultimately in court. A court rejected that because it did seem like it was gamesmanship and said, you can dismiss, but it's going to be with prejudice. I mean, he was behind that, right? And he's alleged to have been behind some other things also that have happened. So what we've seen is somebody whose allegiance is to the president. And I don't just mean, you work for the president. Of course, there's a certain amount of, respect you have to give to the president, but president over the Constitution. So I think it's even before these whistleblower accusations, very concerning to think that someone like that could be on the bench on the Third Circuit, potentially on the Supreme Court, you know, while this administration is defending challenges that have been brought to, at least allegedly, unconstitutional policies and practices. I mean, my own organizations, we are litigating the birthright citizenship case. We just were in court today on the rescission of temporary protected status against Afghans and Cameroonians. And imagine if Emil Bove was on the Court of Appeals reviewing rulings on these things that he, you know, even if he was recused from things that he directly took part at, let's assume we're a few years, you know, another year into the administration, that loyalty he has had so far to the president, I think, is really hard for us to imagine that he would give up, particularly, Jen, if what he's hoping for is an appointment to the U.S. Supreme Court. And so it's a very fraught situation. But this whistleblower letter, which I have not yet today had the time to read all 35 pages, you know, this is not just any whistleblower. This is a 15-year veteran of the Department of Justice, worked under administrations of both parties, including the first Trump administration, immigration attorney who had been in court defending some of these deportations and removals, but who had a duty of candor to the court. He is the one who's told the court in the Abrego Garcia case that Abrego Garcia was deported, removed from this country by mistake, that he had a court order saying he could not be removed to El Salvador. And he got fired for having told the truth to the court. And so he is the person who is saying in this letter, right, that leadership at the department, including Emil Bove, you know, basically this is what the directions were, right, to not be candid with the court and you know, to defy court orders. And so this is one person's allegations, but the allegations he's making, there will be other people that know about those. So the question is really, you know, tomorrow at the confirmation hearing, you know, clearly at least Senate Democrats are going to be, you know, this is probably going to just pervade the questions to Mr. Bove, but one would hope that the Senate across party lines would take this very seriously. Again, it's allegations at this point, but he should be questioned about this, because some of what we've actually seen, you know, like the Mayor Adams situation, certainly are reflected in, and the Abrego Garcia are certainly reflected in this this 35-page letter.
It seems that there are three categories, if you will, of problems with him. First, because he's Donald Trump's yes man, he's an election denier. How can you have someone on the court who says down is up is down, who is just advancing a bald-faced lie, and having been on the other side was presumably consulted and certainly cheering the pardon of January 6 individuals. So that's kind of one part. The other part is what you described. The government is taking very radical positions on a slew of issues. They've lost, you know, over 90 times, because even with a court that has Republican appointees, it's so far out there. So I think it's a legitimate question. Republicans and Democrats always like to ask this of the other side. Is he within the mainstream of legal thought? And the final issue, which I think we should end on, is an ethics issue. Whether he has been candid with courts, there is a pending ethics complaint about that. How should that figure in? Even that, though, that those are allegations, they haven't yet been adjudicated. How does his representations or alleged misrepresentations in front of a court, which presumably he would later be on, affect this process?
Well, it's very important, right? I mean, we look to our courts as a place where not only each one of us who's an attorney, we swear an oath, right? That we're going to, you know, when we get our bar licenses, right, that we will be candid with the court. We subscribe to a set of professional responsibility rules, and judges are held to those rules too. In fact, judges other than the Supreme Court have an ethics code that they have to abide by. And so the very notion of a lack of candor to the court is just complete anathema to the entire rule of law, the entire reason for the judiciary to exist. I mean, it's that place where, you know, I'm not going to say no one's ever lied in court. There are witnesses who have lied on the stand, but the job of the lawyers, the job of the judge is right to make sure they use every tool possible so that that doesn't happen. For the lawyers, you know, the lawyer who's sponsoring that witness has an obligation to do some kind of work to make sure that they're not sponsoring lies, perjured testimony. And counsel on the other side can use cross-examination to try to elicit the truth, and then the judge can rule based on evidence. And so you're talking about somebody going into a judicial position. Now, again, this would be on the circuit, so this would be all appellate arguments and not witnesses in front of Judge Bove if he were to become Judge Bove. But like, these are the ethical questions I think that we all have. Not to mention, it will be his obligation to recuse from anything involving the Department of Justice. And that's not just cases he weighed in on, because when you are in, even when I left the Department of Justice and I was not as high level as him, I had an absolute recusal from participating, on paper in any case against the U.S. Department of Justice, even though I had been in National Security Division. There were many, many hundreds of cases, thousands probably, that I had nothing to do with. But the idea, perception would be, because of the level he was, the perception would be bad for the American people to see somebody had just came out of the Department of Justice and now would be sitting in judgment about over things the Department of Justice is doing. So, but we'll see what, we'll see what position he takes if he's confirmed. And I do think he's going to face something of a tough road on confirmation. There's another point I'd raise, because who's giving the Senate the information they need about this? Historically, until just recently, the American Bar Association gave its rating for all judicial nominees by Democratic presidents, nominees by Republican presidents, and would judge them either qualified or not qualified, etc. And they would review these kind of things like ethical issues, things like their own experience, education, etc. And the Attorney General not too long ago said, we see the American Bar Association as a biased organization, an organization that's biased against this administration. So we are not going to seek their opinions, nor will we accept them or give them any consideration. And that means this, whatever people may think about ABA, I mean, there are people of all political stripes that belong to the American Bar Association across the legal community. It's typically pretty conservative. And I don't necessarily mean politically conservative. I mean just conservative, and it's not bombastic, right? It's not hyperbolic. And so that's taking away, an important kind of resource. And you have to wonder, and that really is leaving the vetting kind of just up to the administration. And this is the administration where you wonder how rigorous that vetting is. And of course,
Exactly.
Bove, we all know about him. So.
And I will end on this, which is the issue of recusal should be a topic at the confirmation hearings. Is he going to commit? And then, of course, if God forbid he should get on the court and go to the Supreme Court, we still do not have binding ethics rules on them. And we have seen over and over again very questionable decisions, at least from the outside, as to why a justice didn't recuse. So you could imagine him playing nice, doing what he's supposed to do. Then he goes up to the Supreme Court and suddenly he is ruling on cases that he was directly involved in. And there's not a thing we could do about it, because the Supreme Court has made themselves their own judge. And that, friends,
there's a political solution, right? It's just one.
Yeah, there is. And it's making me a believer in expanding the court and in term limits, which I never thought I would be in favor of. But sometimes an idea, its time has come. So thank you as always, Mary. We love having you on, and we'll look forward to seeing you soon.
Thanks, Jen. Always a pleasure.